Hello everyone, the topic for today's discussion is how safer online messenger portals and whether the same are admissible in the court of law as evidence. Several online messenger portals like Signal, WhatsApp, Telegram, etc. allow a user to send text messages, images, video, documents, etc. from one device to another. WhatsApp guarantees the secrecy of such communication to its user as the chats are end-to-end encrypted. That means no third person, not even WhatsApp, can read or listen to them. End-to-end encryption means that such audio, video, documents, etc. cannot be intercepted by anyone when it first travels to the server and from there to recipient's phone. Even though it is not easy to decrypt such encrypted messages, government agencies can procure the data from the storage in a user's device. In December 2018, the Ministry of Electronics and Information Technology proposed changes to Section 79 of the Information Technology Act of 2000, making it mandatory for online messenger portals to enable tracing out of originators of information when demanded by law agencies. Now, all electronic messages transmitted from one device to another are stored on the receiver's phone, the sender's phone, the server of the service provider, and on cloud or Google if allowed by the user. Messages saved on this storage are not encrypted and can be read by anyone. Several hackers and government agencies are alleged to have used spyware on targeted devices where decrypted messages have been retrieved and even read live. Interestingly, in December 2018, one such account was hacked of the very famous Jeff Bezos when he received a missed call on his WhatsApp. Pegasus was able to target the vulnerability in WhatsApp's VoIP stack, and in order to hack a person's account, all that was required was a missed call to WhatsApp, and then they could hack into a person's contacts, messages, live locations, camera, and in fact even GPS live locations. Now, it is not just a conversation, but these softwares can help probe agencies with information like metadata, which are very crucial in identifying leads. Now, metadata refers to the log of chats and phone calls between different users. It has information on timestamps of messages, IP addresses, geolocations, details of contracts, etc. Moreover, the WhatsApp messages can also be retrieved by a process called cloning on another phone that can be used to obtain a mirror image of the original. National Investigation Agency in 2019 was able to track Jaish-e-Mohammed commander Umar Farook, the main brain behind Pulwama attack of 2019, in which 40 CRPF troopers were killed as he did not destroy his phone properly. You have to understand that the Information Technology Act of 2000 not expressly and directly does not protect the privacy on such platforms. In fact, under the Indian Evidence Act of 1872, even deleted messages can be retrieved and are admissible in the court of law as evidence by forensic experts. The Supreme Court of India redefined the electronic evidence norm in a very famous case of Arjun Pandit Rao Khotkar, making it mandatory for police officers to follow the guidelines under Section 65B of the Evidence Act. Any electronic evidence now produced by a police officer legally has to be provided with a certificate. Now, this certificate can be procured by the user itself or through a forensic expert. If the device owner can certify the same, it is well and good. But in case the law enforcement has procured the same under Section 76 of the IT Act of 2000, which provides for confiscation of devices, then it can also be certified through a forensic analyst or an expert. Section 43A and 72A of the IT Act penalize improper disclosure of information. Information Technology Rules of 2011, read with Section 43A, defines sensitive personal information like financial information along with other information that prohibits the law agencies from transmitting the same. Under Section 5 of the Telegraph Act of 1885, the Union Home Ministry or Home Secretary of State can order the interception of a phone in order to protect the sovereignty and integrity of the state, public order, etc. Even though such interception cannot last for more than 180 days, your phone calls can be intercepted by the government agencies. Now, we have seen law agencies using such online messenger platforms several times, whether legally or arbitrarily, in order to procure information, like in Sushant Singh Rajput's case, where the agencies were found leaking information to the media, and in the case of other top actors, where their WhatsApp conversations were leaked by the Narcotics Control Bureau. Now, the impunity practices by media houses to publicly air the conversations are a serious infringement to the right of privacy of an individual. Irrespective, such chats can be procured by law agencies, even though it might be end-to-end protected, and are admissible in the court of law as evidence if the same can be certified by the user or a forensic expert. Even if one destroys his phone or her phone or the storage of the same can still yet be procured through metadata. Therefore, be wary of your messages and the information you're circulating on such platforms, as the same is vulnerable and can be traced and procured by law agencies and is admissible in the court of law as evidence if the same can be certified by the user. If not in case of the user, then a forensic expert. I hope this was of much help to you. Stay tuned for much more